Do you ever wonder what LAROW is? Hello everyone, welcome to LAROW 101! Today, we embark on a fascinating exploration into the world of land law, unraveling the complexities of land administrators' right-of-way. So Iman, can you tell us a bit about the meaning and purpose of LAROW?
Of course, land administrator right-of-way or LAROW is an essential legal tool for guaranteeing access across alienated land and situations like easement denial. LAROW is a right of pass and repass issued by the land administrator, which comprises of the state director and registrar of title and is governed by the National Land Code. The power includes the ability to create LAROW with or without the approval of landowners, as long as the state authority, the owner, or the occupier of the alienated land submits an application. Usually, the National Land Code grants the land administrator the ability to create specific rights of way over land, ensuring that these rights and associated responsibilities are legally binding on both current and future proprietors and occupiers of the land. This helps maintain consistency and continuity in the management of the rights of way, regardless of changes in property ownership or occupancy.
So, how does the law contribute to the interpretation of LAROW? And can you explain the nature of LAROW?
To discuss this better, let me tell you what is meant by a public terminal as illustrated in section 387 of the National Land Code, where it is the foreshore or a river, railway station or public road. To add on, section 388 subsection 2 ensures that the established right-of-way remain a permanent and integral aspect of the land, and all subsequent owners or occupants are obligated to adhere to them. This legal continuity is designed to maintain the intended use and access condition over the land, irrespective of changes in property ownership or tenancy.
So, I believe that there are different types of LAROW. Husna, can you provide us insights on that?
Sure. Based on section 398 of the National Land Code, the land administrator right-of-way can be classified into two types, which are the public right-of-way and the private right-of-way. So, the public right-of-way is designed for the benefit of the public, which means that it allows access between specified lands and public terminals. When the land administrator creates a public right-of-way, it is important to note that it is solely for access. Users of public right-of-way are permitted to pass and repass a specified area of land to reach a public terminal, regardless of whether they own or occupy the land in the neighborhood. However, the use of right-of-way is subjected to conditions stated by the land administrator. While in contrast, private right-of-way is established for the benefit of the proprietor or occupier of alienated land to facilitate passage between the land and public terminals. To elaborate, a land administrator may establish a private right-of-way to allow anyone to pass or repass a public terminal, either for the advantage of the state authority or for their own benefit. The owner or occupant of the alienated land must be the one for whom the right-of-way is established. Hence, with the right-of-way granted to him, he might be able to provide anyone using the land permission to travel by the public terminal once and then again, as authorized by the state authority upon its application. Moving on, under section 390 of the National Land Code, the creation of the private or public right-of-way is executable only if the land administrator deems it satisfactory that it is indeed expedient to create the right-of-way. Then, such order shall be made.
So Herr, could you briefly explain the procedural aspects of the creation of right-of-way?
To section 391, subsection 1 of the NLC, the land administrator should first cause the road of the right-of-way to be surveyed according to the procedure listed in Part 29 of the NLC, and require the issued document of title or known as IDT to be delivered to him right after the order of the creation of right-of-way is made. Upon receiving the IDT, the person who makes the final endorsement will depend on whether the land is held under the land office title or the registry title. If the land is held under the land office title, upon receiving IDT, the land administrator should make a memorial of the right-of-way through Form 28B on both the registered document of title and the IDT. The route of the right-of-way must also be shown on the IDT. On the other hand, if the land is held under registry title, the land administrator, upon receiving the IDT, must send it to the registrar with a copy of the order creating the right-of-way. Then, the registrar will make a memorial similar to what the land administrator did and later return the IDT to the person entitled to the said IDT.
So, Genevie, what are the expenses associated with the creation and the maintenance of a right of way?
By referring to the Section 392 of the NLC, which the cost of surveying, constructing, maintaining, or repairing a land administrator's right of way shall be borne in private right of way, which is by the authority or person for whose benefit it has been created of public right of way, which refers to the state authority. So basically means who gets the benefit from the creation, who shall pay the cost. Moving on to the compensation part, which is stated in Section 393 of NLC, Clause 1 states that the compensation shall be payable to any person for the use of his land as the land administrator's right of way for any damages suffered in respect of trees, crops, or buildings to which he is entitled as a result of creation of the right of way. The case of Kelab Pinang Pulau Pinang had highlighted that the phrase for the use of his land under Section 393, Clause 1 of this section indicates that the affected landowner is entitled to compensation for the use of his land that is creation of right of way. It is also essential to look at Clause 2 of this section as it explicitly stated that the amount of compensation payable under this section shall be determined by the land administrator. It is important to highlight that Clause 3 stated that save as provided by this section, no person shall be entitled to the compensation for damage suffered as the result of creation of a land administrator's right of way, which we can interpret it in an easier way is that otherwise than this section, no person shall entitled to it.
So, Ayra, can you tell us a bit about the sharing of the right of way by adjacent proprietors?
Sure, Hilmi. So, Section 394 allows the proprietor or occupier of alienated land adjacent to or near a property with a private right of way to apply to the land administrator for permission to share that right of way. So, the land administrator, upon receiving the application, can conduct an inquiry or investigation, and if satisfied that it is appropriate, an order is issued declaring the applicant's entitlement to share the right of way with specified conditions. Additionally, the order may grant the applicant additional necessary rights of way over other alienated land. So in the case of Liao Tong Tong and Pentadbir Tanah Alur Gajah, the land administrator, which is the first defendant, conducted the first two inquiries, the second of which was held by an official of the land office that the land administrator has selected. The decision-making procedure was ruled to be irregular, and the land administrator's reasoning for the judgment was not submitted to the court. Therefore, the court was unable to assess the reasoning behind the decision. Thus, the land administrator should exercise his discretion properly and reasonably.
I wonder what are the circumstances that lead to the extinction of the right of way.
Well, the creation of LAROW is not perpetual in nature, and as stated in Section 395, subsection 1, there are several circumstances in which LAROW may come to an end. If the land administrator believes that any person has failed to comply with any condition relating to land administrator's right of way, or it is inexpedient that a LAROW should continue, thus the land administrator should hold an inquiry to determine the determination of the LAROW. If the land administrator believes that it is expedient that a land administrator's right of way should continue to exist, Section 395 authorizes him to put an end to it, and reopening any investigation conducted under the NLC is permitted under Section 34 of the NLC under specified conditions listed therein. And so in the case of Tong Pyong Lim and Pentadbir Tanah Daerah, Johor Bahru and another, a second inquiry was conducted due to the non-disclosure of an existing access in the initial inquiry. The court upheld the second inquiry's decision and stating that the LAROW was no longer necessary as determined by the land administrator. The land administrator is required to take action to update the memorials of the right of way in the issued document of title and registered document of title during the order of extinguishment.
That's all for our first part. Now, we have a commercial break and we'll be right back with more. So, here comes the question. What amounts could a police expedient when creating such a right of way? Husna, can you guide us on this?
Sure, Hilmi. The first circumstance in which it is expedient for a right of way to be created is when there is no alternative route from the land to access the public terminal. Let me give an example. John is the proprietor of land A, on which he planned to build a house. However, he faces a unique challenge where the land is landlocked and absent of any road conjoining his land and the public road. Due to this, the construction work cannot be held, as there is no other way for John to access the public road. John wanted to create access by applying a right of way on land B, whose proprietor is a private party, Kelly. So, in a situation such as this, it is expedient for the land administrator to make the order creating the right of way across land B. This is justifiable as it meets the requirement of urgent necessity to reach the public terminal, as held in the case of Cik Ning Binti Bakar and Pentadbir Tanah Kuala Perai. So, when the land is landlocked and there is no alternative route to access the public terminal, it is expedient for the creation of right of way.
I see. So, Ayra, can you tell me about another situation?
Hilmi, there's another situation where it is expedient to create the right of way, which is the alleged alternative road only exists in the plan. Similar to the situation raised by my friend Husna just now, John wanted to create a right of way on land B, owned by Kelly, but here Kelly was dissatisfied by alleging that there was an alternative road. However, the road exists on paper and there is no road that could be used to reach the public road in reality. By applying the principle held in Fredolic Ujo and B. Grace Nanam Sembilan Berhad, where the road only exists on paper couldn't be considered as an alternative road. Therefore, there will be no alternative road for John, and it is expedient for the land administrator to create a right of way on Kelly's land. It's clear that the so-called alternative road that only exists on paper will cause the right of way expedient to be granted.
So, what about you, Genevie? Would you like to add anything?
To add to Ayra's point, it is worth noting that it may also be expedient to create a right of way even though there is an alternative. To illustrate, there is an alternative way for David to access the bridge. However, the road is dangerous for people and vehicles to cross along, as there are frequent landslides after rain, which will often occur in a tropical country like Malaysia. So in this situation, David is expedient to apply for the creation of right of way on land B, as the road could be impractical in use and therefore he meets the requirement of urgent necessity held in Chinik Bakar's case. Thus, one who wishes to grant the right of way on another's land must first prove that the alternative routes available are impractical to be used.
We have seen the circumstances that are expedient. How about those that are inexpedient?
On the other hand, one of the expedient circumstances to grant order creating the right of way is where the application of the right of way is merely based on the grounds of convenience. To give an illustration, Eva has an alternative route to access the beach, but it is a longer way. Consequently, she wanted to grant an order creating the right of way on land B, as it is more convenient to reach the beach. According to C. Rusa in Sendirian Berhad and others, and the collector of land revenue Port Dickson and others, mere convenience is inexpedient to create the right of way. By applying this principle, the land administrator could not grant the order for creating the right of way to Eva, as there is an alternative route, although it is more inconvenient. So, LAROW is not objected to create convenience for the applicant, as it aims to allow the landlocked owners access to the public terminal.
Ah, really? So Ayra, do you want to add anything on top of that?
Sure, Hilmi. Besides, it is also inexpedient for only based on the ground that the alternative road is a river to create a right of way. For example, Ahmad owns land A and he used to send his goods to the market located beside the river through boats, but he wanted to create a right of way on Lisa's land, which she objected to. By applying the judgment of Taat Yik Plantation Sendirian Berhad and Pentadbir Tanah Hilir Perak and others, Ahmad must first prove that the river is dangerous to be used in order to grant the right of way. Here, Ahmad could not allege that the river is an unreasonable and impractical alternative route, as they often use it to transport the goods to the market. This situation is inexpedient for the right of way to be granted by Ahmad. So, when there's a river adjoining the land which is suitable for transportation, there's an alternative route and the said land could not be regarded as a landlocked land.
So, what did we gain from today's show? We have dove deep into the world of LAROW. What is LAROW and what is the significance of it, and many more. Not only that, but also we have learned about whether it is expedient or inexpedient when seeking a right of way. Those are some useful pieces of information that will help you in the future. Thank you for tuning in. Goodbye!